If you can just go behind the podium, please. Thank you, ma'am. All right, good evening, ma'am. Could you please state your name and provide your date of birth?
Sandra Little Elk.
Thank you, Ms. Little Elk. And for the state, please?
George Kellerman from the Maricopa County Attorney's Office. Good evening, Your Honor.
Good evening, Mr. Kellerman. So, Ms. Little Elk, you are here on a Superior Court new case. I find probable cause for the allegation of one count of aggravated assault. That is a Class 3 felony. I've appointed you an attorney. You have a status conference September 19th, 8:31 a.m. Preliminary hearing September 23rd, 8:31 a.m. at the downtown Phoenix Superior Courthouse. Mr. Kellerman, the state wishes to be heard regarding the bond and release conditions, correct?
Yes, Your Honor. Your Honor, according to Police Form 4, Miss Little Elk, within her residence with other family members present, attempted to stab her mother, and she was stopped by her grandfather, and then she stabbed herself. The state believes that this bizarre and erratic behavior demonstrates that she's in extreme danger to her other family members. And so the state would request a bond of $50,000. State does not object to that being secured appearance. Thank you.
All right. Thank you, Mr. Kellerman. So, Ms. Little Elk, you have the right to remain silent. If you do wish to be heard regarding, the state's asking for a $50,000 bond, if you wish to be heard regarding that, you may do so. Again, you have the right to remain silent, and you are entitled to an attorney that I have appointed to you. Unfortunately, we can't provide you one today.
Do you know when I can get one?
Yeah, you'll have one appointed at your next hearing, which will be September 19th.
So I'm only able to leave on bail, right?
Well, yeah, so the state's asking for a $50,000 bond. Again, do you want to be heard regarding what you think an appropriate bond or what you think would be appropriate in this case?
Just my family and me are really struggling, so we don't really have that much at the moment. But if you could hear me out and try to help me out a little bit at least from there. This is my first time being in court. So.
Okay. Do you have anything further?
And I deeply apologize.
Okay. No, thank you, Ms. Little Elk.
You done?
Yes, so I guess my concern is that the Form 4 just does not have a lot of information in it. So, Ms. Little Elk, the state constitution requires me to set a bond based on a number of factors, one of which is victim safety. And that's the main one that I'm considering here, is how best to protect the safety of the victims.
Right. I mean, I can leave the house, the premises, and just get trespassed if anything.
Okay. Well, all right, here's what I'm going to do in this case. And I do note that you don't have any prior criminal history, Ms. Little Elk.
No.
Again, I don't know what happened. I wasn't there. The Form 4, what the police provided, just does not have a lot of information.
Right.
And so what I'm going to do is set a $10,000 bond. So it's not the $50,000 the state wants. It is a $10,000 bond. It is a secured appearance bond, which means you can pay that directly or work with a bail bonding company. They generally require 10% plus collateral. 10% of $10,000 would be $1,000. So if you pay your bond, you will be released. You're then promising to go to court on all of your court dates. You'll have an ankle monitor installed, and you must comply with pretrial services for supervision. You also have the standard conditions and restrictions of release. In addition, you're not to return to the scene of the alleged crime. You're not to initiate contact with any alleged victims, complainants, or witnesses, or have any physical contact with any alleged victims. You're not to possess any weapons You must find an alternative residence, provide proof of the same to the court, and you must obey the terms of any order of protection or injunction against harassment that has been issued or which may be issued. So you can have no contact with the alleged victim or victims for any reason, even if they contact you first. You also may not reside at the same location as any victims, even if you are an owner or renter of the residence. You are entitled to one civil standby. That's where you contact local law enforcement, schedule a time to meet an officer who will escort you to the residence so that you can obtain your essential belongings. And Ms. Littlelove, just so that you're aware, this bond can be modified by another judge in the future. The conditions and restrictions of release can be modified as well. Ms. Littlelove, do you have any questions?
But it's $1,000, like for...
Well, it's a $10,000 bond, but secured appearance means that you can work with a bail bonding company. And so what happens is when you work with them, you put up collateral, you pay them $1,000, then they pay the $10,000. They may have some other terms, but then you're able to be released. You also can just pay the $10,000 and be released as well. So you don't have to work with a bail bonding company.
I don't have $10,000. That's why I was just thinking the $1,000, and I could be out.
Yeah, so that's, again, you could work with the bail bonding company regarding that.
And where would I find that at?
So when you go back into the jail, there will be phones available to you, and there will be lists of bail bonding companies and phone numbers.
Oh.
All right. Ms. Littlelove, do you have any other questions?
No, that'll be, actually, so I do have to stay until I get the bail bonding?
Correct. You have to remain in custody until you pay the bond, or the bail bonding company pays your bond.
Do you know how long it takes to get back from the bail bonding?
I don't. I mean, from the moment that someone pays the bond, then you'll be released in about 4 hours to 6 hours.
The $10,000?
Or the $10,000, whether a friend or family member pays it, whether a bail bonding company pays it. Once it gets paid, then it's about 4 hours to 6 hours.
Okay, and then with the bail bonding, if I do pay $1,000, then I can be out between.
Well, yeah, I'm not totally sure of their terms, so you have to talk to them.
Okay.
Okay, thank you, Ms. Littlelove.
Thank you.
Oh, excuse me, Ms. Littlelove, just one moment. Mr. Kellerman, does the state have anything further?
No, Your Honor. Thank you.
Thank you. All right, thank you, Ms. Littlelove.
Thank you.
All right, Judah Moya and then Raymond Alvarado will be on deck. All right, good evening, ma'am. Could you please state your name and provide your date of birth?
Yes, it's Judah Quinn Moya.
Thank you, Ms. Moya. And if the state could please announce?
George Kellerman from the Maricopa County Attorney's Office. Good evening, Your Honor.
Good evening, Mr. Kellerman. Thank you for being here. All right, so Ms. Moya, you're here on a Superior Court new case. I find probable cause for the allegations of 2 counts of aggravated assault of an officer, a Class 5 felony, 1 count of assault, a Class 1 misdemeanor, 1 count of disorderly conduct, a Class 1 misdemeanor, 1 count of assault, a Class 3 misdemeanor, 1 count of criminal trespass in the 3rd degree, a Class 3 misdemeanor. Ms. Moya, I have appointed you an attorney, and your case will be heard at the downtown Phoenix Superior Courthouse. Mr. Kellerman, the state wishes to be heard, correct?
Yes, Your Honor.
Your
Honor, based upon the information in Form 4, Ms. Moya appears to demonstrate no regard for community norms and standards, legitimate authority, law enforcement presence. She was in a male bathroom in a commercial store, which in and of itself is inexplicable. When security guards from the store attempted to remove her, she attempted to slam the stall door against one of the security officers, and she bit him. The security officers held her down till uniformed police arrived. When they were taking her into custody, she engaged in a protracted thrashing, kicking, scratching, biting, threatening of the officers. The state believes that she demonstrates all of the signs of someone who is a danger out in society. So the state's requesting a bond of $5,000. State does not object to that being secured appearance. Thank you.
All right. Thank you, Mr. Kellerman. So, Ms. Moya, if you wish to be heard, I will consider what you have to say. You don't have to speak, though. You do have the right to remain silent. Again, I am appointing you an attorney. Unfortunately, that can't happen right now, but you will have an attorney in the future in this case. So, again, it's completely up to you. Do you wish to be heard?
Yes.
All right, you may proceed.
Thank you. I, first of all, would like to apologize to any officers who I may have encountered and had these disorderly conducts on. I hate to admit that I don't really remember any of that happening. I had way too many drinks in my system, and I know that is no excuse. I have been struggling with alcohol abuse in my life, and I am working on getting that on track, and it's just something I know that I need to cut out. I would just like to apologize mainly, and I also am wondering what the next steps for me are.
Okay, thank you, Ms. Moya. Mr. Kelman, does the state have anything further?
No, Your Honor, thank you.
Thank you. And officers, I am editing this slightly. Okay, Ms. Moya, I appreciate what you've had to say. Mr. Kelman, I appreciate the state's position too on this. Ms. Moya, I do note you don't have any prior criminal history. Let's see. Hold on, officers, I need to edit it again one more time here. Okay. So I don't see any prior criminal history. What I am going to do is release you on supervised release. So that means you will be leaving in about 4 hours to 6 hours from now. Okay, your first hearing is a status conference. That's September 30th, 8:31 a.m. Preliminary hearing, October 2nd, 8:31 a.m. Again, I think that there is some concern about public safety here. Again, I note, though, that this is a single solitary incident. And so as you indicated, Ms. Moya, you are struggling, it sounds like, with some alcohol. And so I would strongly encourage you to get some counseling, get some help in that regard. I am going to order that you're not to possess or consume any alcohol. You must comply with supervision. You're promising to go to court. I think I already said it. Status conference September 30th, 8:31 a.m. Preliminary hearing October 2nd, 8:31 a.m. You're not to return to the scene of the alleged crime. You're not to initiate contact with any alleged victims, complainants, or witnesses, or have any physical contact with any alleged victims. You're also not to possess any weapons, and you must submit to DNA testing at the arresting police department within 5 days of today's date. Okay? Ms. Moya, do you have any questions?
Yes, I don't even remember where I was. Is that going to be written out in the packet?
Oh,
I just don't want to trespass on somewhere I'm not sure of.
Sure, that's a good question. Let me just see if it's got the offense location. Just one moment. Looks like it's at Boondocks in Scottsdale.
Boondocks? Okay.
Yeah, the bar and grill. Is that?
Good to know. Thank you.
So would that be an issue for you not to return there?
No, not at all.
Okay. All right. Any other questions, Ms. Moya?
No questions, but at the moment, I just want to say I definitely will be seeking help, and I appreciate you guys being kind about it, I guess. That's all.
All right. Thank you, Ms. Moya. Good luck to you.
Thank you.
Ms. Moya, we all make mistakes, and so it's okay to ask for help. Mr. Kelman, does the state have anything further?
No, Your Honor, thank you.
Thank you, Mr. Kelman. And Mr. Kelman, you're not appearing on any other matters, is that correct?
That's correct, Your Honor. Good night.
Okay. Have a good night, Mr. Kelman. Good night, Ms. Moya. Good luck to you. All right. Good evening, sir. Could you please state your name and provide your date of birth?
Ramon Alvarado.
Thank you, Mr. Alvarado. Mr. Alvarado, before you came up here, did you have an opportunity to review the extradition paperwork?
Yes, I did.
Okay. So, Mr. Alvarado, you have a warrant from the state of Nevada, and you have a choice to make at this time. You can choose to waive your right to an extradition hearing and be sent back to Nevada within 30 days, or you can demand an extradition hearing and that a governor's warrant be signed by the governors of both states before you are returned to Nevada. If you choose to waive your right to an extradition hearing, you would be held non-bondable in Maricopa County Jail for a period of up to 30 days to allow Nevada to come and pick you up. That 30 days will start tomorrow as long as you do not have any local charges pending. If you do have local charges pending, the 30 days will not start until those local charges are resolved. Sounds like you don't think you have any. I don't see any here. I just have to let you know that. So if you have an extradition hearing, that will take place on September 30th at 1:30 p.m. at the downtown Phoenix Superior Courthouse. I cannot appoint an attorney to represent you because extradition matters are civil in nature. However, you can hire an attorney at your own expense if you wish to do so. You are entitled to bond, which in this case would be in the amount of $10,000. It is cash only, so I believe you can still work with a lending institution, such as a bail bonding company, but I don't know what their terms will be. It's probably not going to be 10%. I don't know what they would be.
Oh, so I can't, I'm sorry to cut you
No,
off.
go ahead. You can ask the question.
So I can work with the bail bonds for the 10,000 because they initially said 10,000 at Gilbert when they had first informed me. They just didn't know. They wanted me to wait till I talked to you, right? So then I didn't know if that was gonna stay or not. So.
Right. So it is 10,000, but it's cash only. So again, you can work with the bail bonding company. If it's secured appearance, it's 10%. I think that's guaranteed. But because it's cash only, it's not 10%. I don't know what their terms would be.
Okay.
And there may be other lending institutions you could work with as well.
Okay.
Okay. So if you're unable to pay that bond, you will be held in custody during that time or until another judge modifies your bond. And a governor's warrant signed by the governors of both states is required to extradite you to Nevada. That process could take up to 90 days. So, Mr. Alvarado, do you know which option you wish to go with?
Well, I was informed that I didn't have to make that decision right now.
You certainly don't. So
I do have a conversation pending with my lawyer tomorrow morning,
I see.
and I want to go over this with him.
Okay.
Just so he could, simplify it more for me and give a more understanding so I can make that decision. It sounds like it's a pretty serious decision.
Sure.
That's what it sounds like to
Right,
to everybody else. It might not be, but
No, I would agree it is a serious decision. Here's what I'll say to Mr. Alvarado is, it's true that, you do and you don't have to make the decision, because the thing is, on the 30th, the judge will go through these options again. But the thing is, you can't make the decision tomorrow. You would have to wait until the 30th. So you'd have to have the extradition hearing on the 30th, and then you can decide whether you wish to agree to the extradition or not. In the meantime, though, you can pay post bond and be released.
oh my God, it's so hard. Because I'm planning on posting bond. I'm planning on it, but
Okay.
anything can happen within that, right? So that's the plan. Is there any way my lawyer could set up a court date before the 30th?
Unfortunately, there's not, no.
Okay. So, again, can you go over that? Like, can it simplify it a little bit for me?
Sure. Right, so the options you have are to say, I'm not agreeing to the extradition. And that's fine, right? You don't have to agree to that. If you don't agree to the extradition, then you have a fugitive from justice hearing on September 30th at 1:30 p.m. I don't think it's not like that hearing's, again, if you agreed to be extradited at that time, that hearing then is over, you move on with that. But if you don't, it's not like the hearing happens that day and everything's over and they're going to decide one way or another. Okay? So, or you can choose and say, look, I don't want to fight Nevada on this, I'm agreeing to be extradited. If in that case, you cannot post bond, and starting tomorrow, the 30-day clock starts running that Nevada has to come and pick you up.
Okay. I'll go with the first one.
Okay. All right.
Go ahead.
Go ahead.
Because no matter what, I'm going to go to court on the 30th, right? If I bail out or not, I've still got to be at court on the 30th.
Correct.
Now, if I do bail out and I go to court on the 30th, what do I have to take care of for Nevada, to take care of the Nevada situation?
That's a good question. You'll need to talk to your attorney. Okay? I don't think anything is necessarily happening with Nevada at that point, because everything's sort of on hold waiting for you to be extradited, for that question of the extradition to Nevada. Now, my understanding is that there are some people who get things taken care of with the state, get warrants quashed and stuff like that. I'm not saying you can't do stuff. I'm just saying it's not like you're going to get arrested on another warrant from Nevada unless there's one I'm not aware of. No. It's just that you have to wait to go back on the 30th.
I do know this was like 2016. This was like, and I think the warrant was issued like, 2020 or something, they had told me. But the initial incident was 2016, and it was all misdemeanors, and they just gave everybody a ticket and then sent them off their way. And and now it's a felony, and I don't understand why. I kind of do. I try to make sense of it myself, just because I think every year it kept on going up in the bond, and it raised to $10,000 to where it made it a felony.
And that may be, I don't have more information. I have very limited information with the facts that we have. So the judge at the Fugitive from Justice hearing will have more information. Okay. I just have limited information. Okay. So I am making the decision to be bondable. Okay. And then be at court on the 30th. No matter what, my days won't. Like, if I have to do any type of jail time, let's just say, right, if they're not gonna, 30 days, the 30-day thing, like you said, right? Right, so, the 30 days does not start tomorrow unless you're agreeing to be extradited. Right. So if on the 30th you decide you want to be extradited, the 30 days would begin on the 30th. Right, okay. Yeah, no, I would choose to be bondable. Okay, no problem. All right, so I understand you do not want to sign the paperwork at this time. Your bond is set in the amount of $10,000. You will have a hearing in extradition court on September 30th at 1:30 p.m. at the downtown Phoenix Superior Courthouse, where the judge will go through these options again. If you post bond, make sure you attend all court dates or a warrant will issue for your arrest. Yep. All right, Mr. Alvarado, do you have any questions? No. Thank you for simplifying that for me. I appreciate it. You're welcome. Thank you, sir. Good luck to you.